This conference will now be recorded.
So what he did is effectively say, okay, other than in Miami-Dade, Broward, and Palm Beach, which are three of the counties hardest hit in Florida, he began easing restrictions on employers. As Carlos Zumbano mentioned, he is allowing now, outside of Dade, Broward, Palm Beach, 25% capacity for retail establishments, 25% capacity for restaurants, and various other allowed businesses. So he's basically limiting the effects of the previous restrictions. Now, the other restrictions, although they were set to expire today, he extended them indefinitely. So right now, Dade, Broward, and Palm Beach are still under a statewide order. We are still under the Miami-Dade County order, and you may or may not still be under a city order, depending on where your business is. Now, many of you have asked, and we've answered a lot of questions as to, am I an essential business? Now, essential services are what is defined in the order, and they consist of many categories. A lot of it is medical, but for example, law firms like us are allowed to stay open. Several accounting firms, many other businesses that can be classified as essential services.
Healthcare providers, gas stations, banks, hardware stores, laundromats, some private colleges, but only on a needed to facilitate online or distance learning. It continues. It's a long laundry list.
Yeah, and you've probably been aware of those because that order has been out for about a month and a half now. Now, with this new easing of restrictions, some of those businesses are allowed to reopen even if they were restricted prior. Again, the mayor has not changed his standing order, so the mayor of Miami-Dade County's order is still in effect. The state order is still in effect for Miami-Dade, Broward, Palm Beach at this time. So effectively, if you are in Miami-Dade, nothing has changed for you from yesterday. Even though some orders were expected to expire today, they've been extended and no substantive changes. You may have heard that Carlos Jimenez opened up parks, marinas, and a couple other things, but effectively nothing that affects the businesses themselves has changed in Miami-Dade County in the last few days. So we expect those restrictions to continue. Now, the restrictions don't require you to be closed altogether. It just more or less requires you to close down your physical offices and retail and your retail outlets if they are not one of the essential services. So with that said, many employers have been sending people to work from home, telework as we call it, and as the OSHA guidance calls it. So it's important to distinguish. The business has not been shut down per se, right, other than the physical locations of the business. So many people have been asking, and they've taken many different paths, as Zumbano mentioned, whether it's work from home or possibly furloughing some employees or layoffs. I mean, there's been a lot of ways that businesses have handled it, but up until now, they've handled it well, and we're still in the same spot in Miami-Dade County, at least. Other parts of the state appear to be opening somewhat, and you may fall into one of those categories outside of Dade, Broward, Palm Beach that can open at this time. And good luck to you in that. But so that is an overview of all the orders that have been enacted and how they interplay. So moving on, we're going to talk about the OSHA guidance. So OSHA has issued guidance on dealing with COVID-19. I have to warn that this guidance was actually put out last month, so it is a little dated in that things change almost daily, but they haven't updated this yet, and it appears to be a good roadmap of how to proceed now.
And before we get into it, it's important to talk about this. OSHA has taken the initiative. Why? Logically, OSHA deals with workplace safety issues and things of that nature. COVID-19 is a threat to workplace safety. So it's not surprising that OSHA is a leader in coming out with guidance for businesses on how to bring back employees and get the workforce ready. Now, we're going to go into several categories of how they've laid it out. And they've done a good job. And Regis will have this 35-page document available. And it's very, very helpful. What it does is it goes into whether or not you fall into a certain risk category. We're going to get into that now. But pay pay special attention as we go through this as to where you think you fall. And if you fall within a certain category that OSHA has delineated, what are those recommendations? Not legal, statutory, regulatory requirements, but what are those recommendations and guidelines does OSHA have for you? So let's get at it.
Okay, so a little bit of a big picture idea. As Carlos just mentioned, OSHA is concerned about work and employees' safety, employees being able to perform their work safely. So that is why they are involved in this. CDC also issues guidelines, but those guidelines are for the general public. So they're not employer-employee minded, but general guidelines. For example, CDC has issued general guidelines that if you can't maintain, 6 feet distance, then you should wear a mask in public. Things of that nature. Those CDC guidelines still apply, and they are guidelines too. So they're not laws at this point, but guidelines for the general public to follow. But OSHA obviously more directly impacts employers and how they deal with their employees. It does not affect how people deal with customers generally. Customers, if they don't want to wear a mask when they're walking around, OSHA can't govern that. But either way, they do govern how employers interact with their employees and how they make workplaces safe, even for employees and also customers. So OSHA issued a 35-page outline called Guidance on Preparing Workplaces for COVID-19. The guidance focuses on various measures that employers should take to make sure their workplaces are safe. Now, that is the overarching thing that basically they interpret this whole guidance through. This is how you are going to make your workplace safe. So all these guidelines are just basically their idea of what a safe workplace is. So the categories that they basically decided to use are called engineering, administrative, work practice, and personal protective equipment. Those 4 categories are basically the outlines and the sections of how you can make the workplace safe for employees. Now, they also divided each job function into 4 categories. There is very high risk, medium risk, and low risk. We'll talk about that in a minute of how each one applies to you. And importantly, you could have some employees that are high risk, some employees medium, and some employees low, even in the same general area. So,
and most companies will fall into the lower exposure risk from a number standpoint. But as we go through it, some of you may be higher risk, medium, very high, and we'll go through some of these definitions. But I think what OSHA is saying is that for the most part, most companies that don't deal with COVID-19 and those type of safety issues are actually going to be in the lower risk category with that different criteria. Okay, so here's some guidelines.
Okay. Okay, so OSHA require.
Oh, I think.
Sorry.
Yep, I'm here. Yep.
Okay. This again goes back to OSHA's overarching image is they gotta make sure their employees are safe. Now, again, the specific guidance that they issued in this 35-page document is, and this is language from the document itself, that this is advisory in nature and informational content, but it is not a standard or regulation, and it neither creates new legal obligations, importantly, or alters existing obligations created by OSHA.
But why is this important? As we go through this, and it'll be a brief overview, as we go through it, what if there is an OSHA complaint down the road? We now know at least what the expectations of OSHA are if there's an OSHA audit, or if there's something that pops up like that for purposes of an employee complaint of a certain condition. We now have at least these tools to help defend ourselves and say, well, this company did follow these OSHA guidelines. In fact, we did, even despite the employee's complaint. If they come in and they do an investigation, being things set up consistent with OSHA is a very good defense for the future.
Yeah, and they also give this kind of as a heads up, because although it, at this point is not a new legal obligation, it may become one in the very near future. OSHA has a little bit of a delay. It takes some time to draft regulations. So there's a chance that they could be basically trying to make these legal obligations. But at this point, all we know is that they may become.
Okay.
Okay, now, very high, sorry.
We're going to start with the very high exposure risk group.
Yeah, levels of risk exposure. So we have the two highest levels, very high and high exposure, are normally reserved for people in the medical field. Now, very high exposure is basically if you're treating somebody that you know has COVID and they are basically creating aerosol generating procedures. They're coughing on you. They are directly, in your space and coughing, or you're doing activities on them that could produce this in close contact. So these are effectively limited to medical field, possibly mortuary services and related things like that. But generally, office type employers are not going to be in the very high exposure group. High exposure group is actually similar to the very high exposure group, but possibly not the people that are forward facing to the patients. For example, high exposure group or high exposure risk may be somebody taking clients in or patients in at the front desk. So they are not directly exposed to people that are being treated and that are sure of COVID, but they are in the area, and although they aren't there when they're doing the procedures, they work in an area where they know that a lot of COVID-19 patients can be.
So you can see how right now in this slide, you can have a company that's a healthcare provider that has both very high risk exposure employees and high exposure risk employees. And therefore, that should be taken into account as we get into some specifics of what those types of companies that have that hybrid or that have those specific risk exposures, what they should be doing to protect the employees. Now we'll go to medium exposure.
Okay, now medium exposure and low exposure risk are probably the categories that many of you are going to fall into. Now, medium exposure risk jobs include those that frequent and/or have close contact, i.e. within 6 feet of people who may be infected with COVID-19, but who are not known or suspected patients. Now, importantly, OSHA has clarified that in areas where there is ongoing community transmission, workers in this category may have contact with the general public. Right now, Miami-Dade County is considered to have ongoing community transmission. So anybody who has a lot of contact with the general public, ongoing contact, is considered to be basically medium exposure risk. So this is the forward-facing people that deal with customers coming in off the street, anybody that regularly deals with the general public. Now, moving on, the lower exposure risk. Those are jobs that, frankly, many of you employers may be in. Typical office. You don't have exposure risk from people walking in constantly, but there is a chance, but nobody knows there's no exposure to people who are actually known to have COVID-19, but there is a chance that you could have it. Most office workers fall into this category. If you only deal with your 15 co-workers in any given day, those are generally the only people you deal with. You don't deal with general public. You're not serving food to the general public. You are not taking orders from the general public in person. That is where most office work is going to be in the low exposure risk.
And you may have a business out there, for instance, that has a back office for accounting, a back office for administrative staff, but then which may be in the lower exposure risk, but then you have those that are on the field that may be classified a little bit more in the medium exposure risk. So take those two into account. That's another example where you have a hybrid that you may have both. If you're a professional office, a law firm or an accounting firm, and all you're doing is staying inside your closed quarters and behind your computer and working, clearly you're more of a lower exposure risk.
Now, these exposure risk levels are basically change on what you have to do to protect your workers. Now, OSHA has recommended a few different types of controls to put in place to protect the workers. The first two are engineering controls and administrative controls. Now, engineering controls are mostly physical barriers and trying to set up physical barriers in between people to prevent the spread. One of the first things that they recommend is installing high efficiency air filters to filter out particles in the air circulating. Also, increased ventilation rates. Sneeze guards is a big thing that they like, is installing sneeze guards. For example, if you work in an office complex and you have low walled cubicles, consider raising up and putting a shield there to prevent even more mixing of air and mixing of people's vapor. Now, second is administrative controls. Typically, that's things that as employers you do with employees to prevent or lessen the spread. Now, these things include sending people home, encouraging people to stay 6 feet away, replacing face-to-face meetings with virtual, like we're doing right now. There are many ways to prevent it from an administrative standpoint that don't involve installing things, but just having people wash hands frequently, just be safe in general. And those are things that you can enforce as an employer. You can require your employees to, for example, cancel all in-person meetings, attend all meetings by phone, things of that nature. So these are things that you would direct your employees how to change their behavior for the better.
And you're seeing that already across the board, at this point in time. You're seeing many businesses that are doing Zoom and they're doing virtual communications as opposed to in-person meetings. Professional offices with clients. Some clients don't want to come in person, so they'll do virtual meetings. Even in the litigation standpoint, for law firms, for instance, the court systems, sometimes they're taking depositions from a virtual perspective, hearings telephonically. So the world has become a bit more proactive on these administrative controls that are a key part of OSHA's recommendations. And it may be something that stays a little bit longer than people think after the opening up of businesses takes effect.
Yeah. And next, safe work practices is a similar idea, but it's providing a little bit more physical things to help out your employees and keep them safe. For example, no touch garbage receptacles, providing lots of hand soap, alcohol-based disinfectants and hand rubs, disposable towels, and giving that so employees can clean their own workstations.
And that's important especially is a tool that should apply across the board, even for the lower risk businesses. Those are essentials that employees appreciate and that can help keep the offices tidy.
Yeah, and the way OSHA recommends how to implement these all depends on what risk area or what risk level you are at or your employees are considered at. And we'll get to that in a minute. But last but not least, and OSHA actually points this out, that PPE is the last category and should be the last category to be addressed. We'll see in a minute how sometimes PPE is not even recommended, but either way, PPE in OSHA's mind is the last line of defense, and many times, at least in low risk, they don't even recommend PPE.
All right.
So talking about PPE specifically, OSHA's stance is that if you are required to have your employees in PPE, the employer's job is to provide it. So it is the employer's responsibility to provide a PPE for employees who must have it, according to this OSHA risk levels. Importantly, workers with medium exposure risk, they say, may need some PPE. And remember, this is the forward-facing people that deal with the general public. You've seen it already probably at restaurants, people picking up food. The people that are giving you the food probably already have PPE, face shields, masks, things of that nature. But the cooks in the back may not have it.
And clearly, if you're in a hospital, your PPE will be much, much more extensive than somebody's more, of course, in a back office and so forth.
Yeah, very high levels, exposure risk and high exposure risk, both basically, they must have PPE. Again, I'm trying to address you all who are probably not in the medical field directly and probably not treating COVID patients. So we're aiming more towards the medium and low levels of risk. So in the medium level of risk, they say you may need it. And again, this can deal with how many customers you deal with. And OSHA does say this is an individualized analysis. So you can't look at this as the end all be all. You have to look at your business and see what the risks are. But they do recommend in medium exposure risk, which as we know is probably most businesses here who have any forward-facing clients would probably fall into medium risk, because the general public, there is community transmission. So if anybody deals with the general public, it's probably going to be considered medium risk.
Yeah, and they give you quite a bit of examples: gloves, gown, face mask, face shield, goggles. What do you do as a business? And the companies have some discretion here to take a look at their business model, their operations, and figure out, okay, we've gotten some guidance. This is not a law, it's not a regulation, but we've got at this stage, at this time, but we've gotten some guidance. What is it that I need to do for my employees to keep them safe? And these are some of the examples that they're giving.
So now moving on, low risk. OSHA actually specifically says that PPE is not recommended for workers in low exposure risk group. That is the back office people that only have contact with a few people. It is not recommended by OSHA for any low level risk employees. Now, there's an important thing to note there that, well, first off, this can change. You know, as I mentioned, this OSHA guidance is already kind of old compared to the way things are moving now.
It's amazing we're saying 30 to 35 days is old, but it is old, right?
But, you know, it could change. Many of this OSHA guidance came out right when some states were starting to make the stay-at-home order. So there is a chance that this can change. CDC also has recommendations for the general public. Again, right now they're recommending people wear face coverings. So things can change. Now, importantly, just because the OSHA says you don't have to have employees in low exposure risk levels wear masks, the inverse is not also true. So that doesn't mean you can say, no, do not wear a mask. At this point, frankly, we would recommend that employers in all risk categories recommend face coverings, because that may be something that is coming down the pipe and may happen. But at this point, certainly with this pandemic going on, we don't believe you should prevent people from wearing face masks in any way, even if they are in the low risk category and OSHA doesn't say you have to. And also, just to note, some industries have industry-specific requirements for PPE. So you may want to check out that on what kind of business you are. Is your industry based on, you know, national codes or what have you, or even state orders may have a requirement for PPE in and of itself. And then it doesn't matter what the OSHA requirement is, because you also have to follow the state requirements.
All right, so let's turn to a question. You have employees that return to, that we've had already in the past. You have employees that are returning to work. Can you take the temperature of the employee? It's a good example. Can you take them? What measures can you take as an employer to try and protect your employees? Well, let's talk about this all-important issue, because it is something that is in the media and it's talked about quite a bit, and a lot of people are unclear about this. Normally, let's talk about outside COVID-19. The ADA, the American with Disability Act, generally would prohibit you from medical inquiries or examinations, which would include temperature checks in a workplace setting. However, recently, the Equal Employment Opportunity Commission has recently said that now you can do so during the pandemic. So it's a very different scenario during the era of COVID-19 compared to before. You can bar employees with elevated temperatures from entering the workplace. So imagine that. Who would have thought that an employer can actually take the temperature of his employees and say, no, we're turning you away from work? But that is permitted, but certain guidelines should be followed. You should take the temperature checks as part of a back to work plan, an overall plan that makes sense for your employees, so that there's clarity with the employees. And you should apply it across the board uniformly to avoid any type of disparate treatment or discriminatory type of claim from employees. Remember that many people who contact COVID-19 do not have a fever or otherwise asymptomatic. Taking temperatures, though, as a whole is permitted with a few other criteria that we'll get into now.
Yeah, and very quickly, even the Governor Ron DeSantis, in one of the emergency orders he issued, 20-68, he already said that, for example, restaurant employees, as a restaurant owner, you have to bar employees who may be showing symptoms from coming in the restaurant. So you actually have a duty to prevent them according to the state emergency order 2068. And that has been extended as part of what he announced last night. So that is still in effect.
So let's get into how do you go about doing temperature checks if you decide to go down that path. Well, you can appoint somebody internally with proper training, ideally an on-site medical staff person or another medical professional, registered nurse, for example, if possible. But sometimes you can't do that. It's not a requirement, it's not a law, but it's of course recommended. And those it's to facilitate or administer proper on-site temperature checks. Importantly, whoever does it, no contact thermometers are preferred. Why? It's for a lot of reasons. Nobody wants to have a claim arise as a result of somebody dinging the head of somebody else and taking the temperature. No contact is preferred, clearly. Set a temperature threshold over which employees will not be permitted to enter the workplace. For instance, the CDC considers a fever at least 100.4 degrees Fahrenheit, which is obviously something that many people will look at. You want to say something?
Yeah, and very quickly, the CDC has also said that you don't have to actually have somebody physically taking every person's temperature. You could require them to take their own temperature and show it to an administrator.
Right.
So you can literally have a temperature thermometer or non-contact one sitting there, and they have to take their own temperature and show it to somebody before they're allowed in.
Absolutely. So now it's clear those individuals, whether they're outside nurses or whether they're internal administrative staff that are taking the temperatures, it's most conservative to treat the temperature test facilitator, that individual or individuals that is taking that, as high, very high risk exposure for purposes of the OSHA guidelines that we just discussed. Why? Because they'll likely be in proximity to a large number of workers, including potentially infectious individuals. And everything, it's important, when they take the temperatures, keep the temperature confidential. Be mindful of the requirements under ADA, confidential medical information, HIPAA. The identity of workers exhibiting a fever should only be shared with members of company management with a true need to know. None of that changes. All of those HIPAA privacy laws, it's important to keep that close-knit and private. We've spoken about this in the past when there's an individual that tests positive for COVID-19, and how if you're going to give a general statement to your staff, don't identify the employee. All of those issues still apply. Same concept. So things to consider. To recap the OSHA guidance generally: develop an infectious disease preparedness and response plan if one does not already exist. You can take into account the OSHA recommendations we've just gone through. Be aware of workers' non-occupational risk factors at home and in community settings. Are they an older employer? Presence of older aged employees, presence of chronic medical conditions, including immunocompromising conditions, pregnancy, and so forth. The need for social distancing, staggered work shifts, downsizing operations, delivering services remotely, and other exposure rate reducing measures should be analyzed if possible. We'll get into some of this a little bit more, but remember, even though you're going to be returning to work, teleworking is still encouraged. Staying at home is still encouraged. We understand that after it opens up, there may not be a legal requirement to force people to telework, but at the same time, there's nothing wrong with encouraging telework.
Yeah, and remember, this applies to those people that may be exhibiting symptoms. You are actively, trying to keep those people out of the workplace. So if they come in or they say, my mother, tested positive yesterday, we've been in the same house. This has to do, and this should be part of your infectious disease preparedness plan, but you should be able to tell them, go home, take time off. We need 2 weeks. We don't want you right now because you could have the virus, and we don't want to affect our other employees.
Yeah, it's going to be a fluid, kinetic analysis as a business to try and accommodate this COVID-19 return to work plan. It's going to have to be a day-by-day assessment, because there may be employees that are coming in with symptoms. There may be employees that are coming in with COVID-19. How do you continue to prepare your business for dealing with those issues once you have the green light to come back in? You could still use tools you're currently using from a remote standpoint. Prepare to implement basic infection prevention measures. Like we just spoke about, encourage workers to stay home if they are sick. Prompt identification and isolation of potentially infectious individuals is critical to protecting your team and visitors and others at the work site. You should inform and encourage employees to self-monitor for signs of symptoms of COVID-19 if they suspect possible exposure. If an individual wants to stay home because they've advised you that they have the symptoms, it is encouraged for these individuals to self-quarantine and seek medical treatment at this point. The virus has not gone away, despite the fact that we're beginning to open up. Take steps to limit the spread of respiratory secretions of a person who may have COVID-19. This goes back to the OSHA guidelines. Face masks, if they're feasible and available, and ask the person to wear it if tolerated. So you deal with those issues on a very fluid basis. Discourage workers from using other workers' equipment, such as phones, desks, offices, or other work tools and equipment, for obvious reasons. You want to also, as a whole, many of you are probably already doing this, keep good regular housekeeping practices, routine cleaning, disinfecting of surfaces, equipment, and other elements of the work environment. All right, so that's the physical assessment from a business standpoint of dealing with return to work issues in light of OSHA's guidance. Let's move on to a few issues that have come up that are important for discussion as we wrap up before we get into the Q&A session, and that is ceasing telework and issues pertaining to policies for return to work and issues that may arise. So continue to telework. That's a big question. Should I, as a company, continue to telework? The government encourages telework, of course, as long as possible. If you're an employer and you're able to telework, you are encouraged to do so as long as possible. And that includes administrative and safe practice control measures, which limits workplace exposure. Telework is something that limits exposure. Why? For obvious reasons. They're at home and they're in a safe location and there's not an interaction amongst the workforce. So even though it may not be required to telework in many instances when you are opening up practices, it is still encouraged. So employers eventually require teleworking employees to work. That's something that you can require. You can require workers to come back. But when you do so, of course, take into account various factors. That decision should be dependent on factors that you consider from a global perspective. Take into account state and local government workplace guidance. Take into account state and local social distancing guidance, including also federal government CDC guidance, operational efficiency needs of the employer, the workplace risk and exposure to infection. Every business has its own exposure risk. And depending on the nature of the business that you do and how you're set up, it can govern whether or not you want to bring back workers or voluntarily keep them teleworking. And of course, employer implementation of the control measures that we spoke about earlier. And of course, recognize at-risk employees who are at risk, the older workers, the pregnant workers, and so forth. Make sure you have a very big picture attitude when you're dealing with returning to work issues. Things to consider for return to work. Evaluate the worker concerns on a case-by-case basis. They may come to you and they may concern about fear and other issues. And those are issues that the company needs to assess. This may involve determining employees that have pre-existing conditions that put them at a higher risk without violating HIPAA laws. That's a very careful line not to cross. Someone may come up to you and say, I have a higher exposure to risk, and I have a situation that is ADA, FMLA oriented. It's a serious issue. It's a serious medical condition. Take them very seriously. And in fact, what the government has encouraged, especially those in high risk areas, those that may have respiratory issues, for instance, and things of that nature, that businesses be flexible and work with the employee during this period of time. Again, going back to before, the era before COVID-19 was very different. Now, these issues can rise to a level of importance where the company needs to be a little bit, or should be a little bit more flexible than ordinary. Employers should also be aware of the FFCRA, the Family First Corona Response Act, which we spoke about in prior webinars, and they provide protections to employees. They require many employees to pay emergency paid sick leave and EFMLA. And for several reasons, as you know, there's very good guidance out there. It's on the posters themselves on emergency paid sick leave, and they include various factors, which include childcare during schools closures as a result of the pandemic. This may not have been applicable, though, if employees were teleworking. So you may have had a situation now where somebody was teleworking in the past, and you bring them, and they were working, and they weren't eligible for the e-leave, we'll call it. Now you're bringing them back. One of the categories, the qualifying categories under e-leave applies, then they can get on e-leave at that time. So although they may not have gotten on it while they were teleworking, it's possible for them to get on it when you return them to work. Employers should also listen to the concerns of their employees and, to the extent possible, provide accommodations for working remotely for particularly at-risk employees. A good practice is to be uniform about that. Try and have a policy that allows you to do things in a non-disparate, legitimate basis for those that are high risk and those that have concerns. If they can work remotely, it's encouraged. And if it's not available or suitable, depending on the type of business, then you should ensure that you've implemented those control measures that we've discussed earlier under OSHA prior to having the return of employees to the workplace. So it may be that you have a practical scenario where you can't have everybody working telework. Okay, go back to what we just spoke about with OSHA. You can read up on, of course, general CDC guidelines. OSHA gives you some great guidance. See what risk category you're in and see if you, prior to bringing in your employees, you can start satisfying those conditions. And you can start doing that now, anticipating that the government is going to open up in the coming weeks and days. Now, an important issue is that if they come back to work, they'll likely forfeit their unemployment. They've satisfied a reduction, unless they've satisfied a reduction in pay criteria. And because the augmented unemployment compensation that they may otherwise receive may go away under certain circumstances because you're bringing them back and now they're being gainfully employed. Of course, they're being employed and making and having compensation come in and money come in. That's obviously something that the employees should be properly reporting to the state when they deal with those issues. Again, general issues to consider: do not use any discriminatory basis in selecting employees for return to work or layoff. Try and have legitimate policies in place. How to notify employees? A great question. When you notify, how do you notify employees? Do it in a manner that you can get confirmation of receipt. When you're notifying employees to return to work, a phone call is good to confirm that they've received it, but also follow-up email and correspondence is encouraged to show that they've actually received the notice to return to work. Do you need to formally rehire? I-9s, for instance. Well, if they've been employed by you, but by your company within the prior 90 days, then you do not need to get a new I-9. New applications, new job applications, that depends more on your company policies in place and whether or not you're going to require them to apply anew or not. That's more of a company existing policy scenario. So now the other issue that might come up is bringing them back under specific compensation arrangements. Will that affect them from their FLSA perspective? For instance, let's say that you've reduced the salary or the hourly wages of employees when they come back. Do they fall under the minimum threshold to be non-exempt? Have their duties changes? Are there any changes in hours or pay that would implement them from being exempt or non-exempt? I clarify that if they fall below a threshold, they may not be exempt, not non-exempt. So analyzing that and working with your Regis HR team is important in this scenario. Is what changes are you implementing from a compensation standpoint and a duties standpoint that may change their FLSA exempt versus non-exempt status? Of course, you want to be careful, of course, about honoring existing overtime, minimum wage, et cetera, and all the existing FLSA requirements that are still in effect. All right, so that concludes a basic overview of some of the more important return to work conditions. Clearly, there are going to be many more that are coming up in the coming days, but I hope through this presentation that you were able to get a good general overview of the all-important OSHA guidance and other issues that you as businesses will consider. We encourage you to speak to stay in contact very closely with your HR team, your Regis HR team. They're a wonderful team, and it's an important thing to be proactive and to be engaged in this process to properly bring your team back to work and set up a plan to bring them back to work. So thank you, Carlos Saladrigas, again. Thank you, the Regis HR team, and thank you all for attending. And we're going to open it up now for questions and answers, unless Carlos and George or anybody at Regis, you have any comments you'd like to make.
No, thank you, Carlos and Joe. That was great. So let's go ahead and get into the questions. I do believe obviously the most important thing here is our safety, our employee safety, our clients and customer safety. But just so everybody's aware, I believe there's already a case pending against Walmart of an employee that got sick and died.
Right.
And suing Walmart for not taking the necessary precautions and so forth. So, besides people's safety, there is a liability issue here that we all need to be aware of. And so, I think this is an important topic, and I hope it was informative. So, Carlos and Joe, if you guys want to go ahead, we'll go to the questions.
Yeah, absolutely. And obviously it's important to be mindful that there is supposedly, the federal government is being proactive, and Carlos just kind of piggybacks on the issue you just raised about Walmart, is that the federal government is being proactive on trying to limit exposure to businesses as a result of course, this extraordinary situation. So you'll see the expectation, at least, although there's no guarantees, that we'll see more coming out for protections for employers as a result of this. But that obviously will be coming out hopefully in the next, at least whatever the clarity on it is in the coming weeks and days. So I know we have a question that says, what are my rights as an employer if my employee refuses to work out of fear of contracting the virus? Very, very, very good question. This issue has come up for us already, and it's an issue. Is fear something that you can actually say is a medical concern? Is that something that, well, surprisingly, I would say during the era of pre-COVID-19, fear in and of itself is not something that is obviously something that is of much concern unless it has a very ADA-oriented or specific medical condition-oriented issue. In this case, there is some authority out there and especially chatter out there at the national level that you should be flexible, and that fear in and of itself Say they're an individual that has a respiratory condition, and that individual says, listen, I believe I'm going to be exposed to COVID-19 and it could hurt me significantly. They're asking businesses to be cooperative. Does the individual go out on FMLA? If they've used, if they haven't used FMLA, can they go out on unpaid? If there's no e-leave available, can they do unpaid FMLA, for instance? Companies are saying more conservatively, put them on paid FMLA. Not, if that's an aggressive conservative approach. Others are saying you're not required to put them on paid FMLA, but at least give them the ability to take care of themselves at home, as opposed to, if they refuse to come back to work, taking aggressive adverse actions such as terminating them. So there is an encouragement to be flexible, especially with those if they have fear that are rooted in real concerns over COVID-19. So I think at this point we're in a chapter of our lives here, of course, dealing with COVID-19, and the encouragement from the federal government is to be flexible and to work with them, as opposed to just simply taking adverse action on somebody who has fear. Is there an obligation to pay if they don't come back, if they're not entitled to pay? No written obligation to pay. Is it encouraged? Some would encourage it. Some would say it's a bit more of a conservative approach. And adverse action in employees in those situations where there's fear, especially where there's a real risk, the concern there is the plaintiff's bar looking at employers and saying that they were unreasonable and didn't act in a reasonable fashion during this extraordinary time.
Yeah, and OSHA itself has some whistleblower laws that say basically if the employee had a good faith belief that some practice of the company, i.e. in this case possibly bring employees back to the work site, if the employee had a good faith fear and they raised that and they were terminated, there is a chance for a whistleblower type lawsuit, at least a whistleblower type action under OSHA. We don't know how far that would get, but as Carlos mentioned, technically, if they don't qualify for any leave, yes, you could terminate them, but the government is stressing for people to be flexible. Now, flexible could easily be unpaid leave. Okay, you don't want to come into work? We're not paying you, but for right now, we're not paying you either. Now, the most conservative thing would be to continue paying them, but again, I'm guessing most employees do not want to take that chance if an employee just doesn't want to come because they are scared. But there are lots of options for paid leave under the Families First Coronavirus Act. So if they don't qualify in one of those categories, unpaid leave is probably a good option, at least in the short term. If they never want to come back, then that's a different story. They are ending their employment. But in the short term, you might want to be flexible for a week, 2 week plus, and give them unpaid leave.
Right, I agree 100%. And that piggybacks on the next question, which is an excellent question, which is, can recognizing at-risk employees potentially open up other discrimination issues? A younger employee complaining that favorable treatment is given to an older employee. Well, under the ADEA, the claim arises for those that are 40 and over being treated differently than younger employees. So it would be, so the protections towards older employees, they are already considered a protected class, the older generation, if you're 40 or over, not the younger generation. It's a great question. In fact, we had a case once that went before the EEOC, someone complaining that they were 20 years old and were being discriminated against, and it was unilaterally dismissed by the EEOC. Having said that, I think it's a bigger question, and that is the concept of disparate treatment, the concept of implementing policies, especially with those that are fearful and have legitimate basis to be feared, to have fearful reasons, and whether or not you allow them, for instance, to telework and not others and so forth. You do it in a very objective, non-discriminatory fashion. Be mindful of protected classes. And when you implement them, will it result in a disparate impact or treatment of different classes that are protected? Genders, age, pregnancy, things of that nature. So I think in the end, if you go, there are protected classes that have their own rights, and it's important to be mindful of that. So I think the more uniform you can be, the better. Clearly, those that have high risk, such as respiratory issues and things of that nature, that the government is obviously saying, hey, important to be flexible under this situation, they clearly, being cooperative with them is something that is encouraged. And we're also frankly hoping to see more clarity from the government on whether or not this potential exposure to employers is going to be minimized as a result of some type of act of the executive branch or some type of act of the legislative branch. So I would think that it's important that when you recognize at-risk employees, you do them on objective factors as opposed to focusing on the illegitimate factors, which are based on discrimination, such as impacting protected classes and so forth. Okay, what if an employee refuses to work? Oh, can you touch about phase 1, return to work, or is that not applicable? Well, I think, well, go ahead, Joe. You want to say? Yep.
Yeah, so phase 1 and a couple of states and a couple of different municipal governments have used this as a kind of their opening foray into opening up the economy a little bit. DeSantis, I believe, called his plan announced yesterday the phase 1 of his plan, which they started opening up some. Again, for Miami-Dade, Broward, and Palm Beach, technically we haven't changed. There's nothing that's changed as far as legislation-wise, because he specifically excluded Miami-Dade, Broward, and Palm Beach from this phase 1. So what he did for the other counties may be a phase 1 for Miami-Dade, Broward, Palm Beach. We don't know exactly when that would happen, or if they would implement the same thing, or maybe even jump us directly into whatever he considers phase 2. But at this point, phase 1 doesn't really matter as far as the state of Florida guidelines. And the phase 1, what they did is basically start opening up. Hey, okay, restaurants can have people inside at 25% capacity, and retail establishments can have people inside again at 25% capacity. So that is his idea of a phase 1 reopening. I'm not sure if that answers the question directly.
And I'll piggyback on that. And also, a lot is starting to open up. There's obviously the position of the state looks as if they're going to be allowing elective surgeries now to continue to flourish, of course, now in the short term, as opposed to postponing those deadlines. Also, what's important is many of you may have businesses in not just Florida, but in other states. Texas, for instance, and Georgia are big examples. Despite the fact that there's phase 1 is a definition that the president did in his national plan, where he had phase 1, phase 2, phase 3, many states, because of the discretion, are choosing, or some states are choosing to bypass some of that very well published and documented summary that you've probably already seen on the presentations when they do the White House press conference. They have decided to do their own analysis and so forth. So I think in the end, it's important that whatever jurisdiction you're in, like Joe just did a great job in this webinar going through what DeSantis calls as phase 1 in Florida, but check your respective, not only county and city jurisdictions where you operate business, but your respective states. We all know about Georgia and Texas, and how, even though it may be controversial in a lot of places, they've been much more aggressive on what they consider phase 1. So I think it's very, very important to read up on that.
Yeah, for example, in Georgia, they, as part of their phase 1, they allowed gyms to reopen.
Right.
DeSantis specifically said no to the gyms in his phase 1. So the phase 1 opening depends on who's opening and who gets to decide that. They're not perfectly uniform, and a lot of them don't even meet the president's criteria that he has issued. So it's up to whatever jurisdiction you're under.
And it looks like Florida is taking a little bit more of a conservative approach compared to Texas and Georgia. They're basically saying we're going to ease into this phase, and we're not going to just jump right into it. Hence, Miami-Dade, Broward, Palm Beach, and their respective closures and so forth. All right, next question. What if an individual refuses to return to work because they are now making more with unemployment benefits? What are the unemployment regulations regarding being offered their job back?
So very simply, if they are able to come back to work and they're available for work and work is available to them, normally they are not allowed to get unemployment compensation. Now, we're obviously not in normal times. Florida's unemployment process has been slow. Frankly, not a lot of claims have actually gone through, and we don't have a lot of guidance. Florida claims, they are making it basically a decision inside the unemployment, which they call reemployment assistance network. So there's a lot of discretion to them, and we really don't know how they are reacting to this. Now, the employer doesn't really have a duty to notify unemployment that basically they want to hire back somebody. There's no duty right now to do that. So some employees are taking that stance. Anecdotally, we've heard that before, and a lot of people fear this because some people could be making more money on unemployment than they are actually working.
Yeah.
The state hasn't clarified how they're going to clear up this, how they're going to monitor this. We don't know yet.
Yeah, and I would say that it would be crazy to at some point to have all of these jobs open up and a numerous number of employees come back and say, well, we just don't want to work because we're making more money here. That was actually a big debate on the Congress floor, and that was that these $600 extra pay through the CARES Act, and so the expansion of unemployment under the CARES Act would disincentivize people. That is coming to a head now, and it's a great question. States do have much more discretion, especially in the COVID-19 era that we're talking about, but it would not surprise me that there would be more clarity from the state of Florida as a result of the COVID-19 virus minimizing, coming down in terms of its infectious rate, and having businesses return to work. The ultimate objective is to return employees to work, not benefit from unemployment for an extended period of time. As you know, in ordinary circumstances, they have an opportunity to work. They should go back to work and forego unemployment.
Yeah, in ordinary circumstances, Florida pays only up to about $275 a week,
right,
which is, can be pretty low, and it is dependent on what you were paid before.
Right.
So it's not a big number. There normally wasn't this possibility that somebody would say, no, I want to stay on unemployment, I make more money. But that is the case now, at least anecdotally. So we've yet to see how they're going to resolve that.
Right, and there's a great, on the website at the state level, there's a great question and answer on there that deals with all of these issues, and we refer you to that because it's extremely informative on numerous issues which deal with these return to work issues and whether or not they're going to be able to collect specific rights and so forth. As you know, unemployment has changed significantly. There's even the ability to apply now as a result of reduced pay scenarios. So it's much more flexible, the existing program, and the state is scrambling, of course, to address the volume of unemployment claims that have come in. Okay, if someone tests positive, do other employees have a right to know that someone tested positive so that they also get tested? The answer to your question is the businesses should inform their team that someone has tested positive without disclosing the identity of the individual and without disclosing any of the protected medical information. So the issue has come is, how do you inform your employees that somebody else has the COVID-19 virus? And the way to do it is very anonymously. It's encouraged to do it because you encourage other people to go get tested if they feel that they've been in contact with this individual, and it allows them to say, okay, I better go. I'm at a point now where I'm experiencing symptoms, or I feel like I need to get a medical consultation. That's the importance of encouraging communication to your employees, and it's also good from an employer disclosure standpoint. But when you do it, be mindful of anonymity. Don't disclose the name or any HIPAA or confidential information to the team. Be very, very careful about how you do it in a very generic manner, but give them enough information so that they know that the importance of potentially them getting tested and dealing with the issue themselves.
Yeah, so the CDC and OSHA have come up with some guidance on this, and basically they say that if you have an employee who tests positive, you should effectively do a kind of mini contact tracing and asking them who they've had direct contact with and who they've had extended contact with, meaning they were within 6 feet for a prolonged period of time. So you're going to ask the sick employee for that information. You're going to turn around and use that information to tell those employees, again, you're not going to tell them who, but you tell those employees, hey, you were next to a person who has tested positive, you were in close contact, we recommend that you go get tested. So that's the easy answer. Now, as to how far back you got to go, CDC and OSHA, they kind of recommend that if it's been more than 48 hours before they were symptomatic, you don't have to notify the individual employees. So if they say, yeah, I got sick today, but I haven't been in the office for a week, there's no real requirement for you to tell other employees somebody you know has COVID.
All right, next question. An employee has been teleworking with no change in pay and has school-age kids at home due to school closures. Employee has also advised that they're finding it hard to get the work done because of the children interrupting. This employee has been keeping a timesheet of what work is being done at home, but never logs more than 5 to 7 hours per day while being paid for 8 hours a day. If we advise our employee that it's time to return to the office, and this one says they can continue to work from home due to the school closure, can we say no to them teleworking and offer them the FMLA option instead? Yeah, so one important issue here is pre-return to work and post-return to work. So when you open up your offices and you offer a return to work program and there's no restriction and the schools are no closed, the school year has ended, and the company is opening up and bringing back people to their offices, they're encouraging you to allow telework, but you can have them come back to work. So that's the first and foremost. If you decide to allow them to telework, important, of course, to make sure that you implement a policy at the company that, of course, is done in a manner that doesn't create a disparate impact or treatment with people in similar circumstances and so forth. So if they're teleworking at home, they're not eligible for, if they're being able to work, then they're not eligible for the EFMLA or E-Paid Sick unless it's on a pro rata basis and so forth, because there's no one there to help them and they have to only partially telework. So in the end, those rules still apply. But once the existing EFMLA and E-Paid Sick Leave laws still apply, but once the schools are closed and the restrictions are lifted and the company wants them to return to work, you can ask them to return to work. As to FMLA, the FMLA, the EFMLA is only applicable as a result of COVID-19. Once you leave the EFMLA, you're dealing with the regular FMLA and the existing laws of the DOL. So you don't have to provide extended FMLA beyond any FMLA that they're allowed to take by returning to work. Now, there might be a scenario where they leave telework, they come back to the office, and they do satisfy one of the criteria for EFMLA and E-Paid Sick Leave. And interestingly, ironically enough, they can go on EFMLA and E-Sick Leave. But beyond that, whether or not you offer them FMLA goes back to the analysis of being flexible and dealing with your team, especially if they're a high-risk situation. But technically, if they don't qualify for EFMLA and E-Sick Leave, and they're not high risk, you can require them to come back to work once the EFMLA and E-Sick Leave has expired, and then you can deal with. Now, you can open up a policy voluntarily at any time that is accommodating, but as a requirement, once they're no longer eligible for EFMLA and E-Sick Leave, you can require them to come back. And if you're going to have them telework, which is encouraged, do it in a uniform, non-disparate manner.
Yeah, and I noticed there, it talks about they only work 5 out of 8 hours that they're supposed to.
Right.
If they are exempt, you still have to pay them for all, the weekly amount for every week. But if they are non-exempt, then you don't have to pay them for 8 hours of work if they only do 5 hours of work. It's an important distinction there. I'm guessing the person you're talking about here is exempt, so you have to pay them the same amount weekly. And technically, they're not limited to 8 hours a day, although they are working reduced hours. But as part of the FLSA exemption, you got to pay them that same amount every week, no matter how many hours, above or below 40 hours that they work.
And remember that if they are hourly and they're not under the salary approach and they are seeking partial EFE leave, that's a different scenario. But that's an important point that Joe just raised, and that is, are they salaried or are they not? And what may very well happen is that when everything blows over and you bring them back to work, remember EFMLA and E-Sick Leave up until December 31st. So that gives them the ability to claim it if they qualify under one of those scenarios. And you remember EFMLA is now limited to one qualifying condition, and that is inability to go to their children's schools being closed as a result of a public emergency. When that's all lifted and that's all gone, then it becomes a bit of a different scenario to qualify when you want them to come back and return to work, and whether or not they've already used the EFMLA, and if their schools are no longer closed, whether or not they're even eligible for EFMLA. So there's a lot of moving parts there on timing. So I think to answer your question, take it from a timing perspective. Is it going to be pre-return to work, post-return to work, and what ramifications does that have? All right. I think that's it. I don't think there's any other questions. No. Carlos, George, and Regis, do you want to take it over from here?
No, I think that's it. Carlos and Joe, thank you again. I don't see any other questions.
Carlos, actually, if Zumbi, if you don't mind, if you could just go over to that final slide real quick, just to let everybody know.
I'm sorry. There you go.
No problem. So this final slide here, just so everybody's aware, this COVID-19 HR guide for employers. Our team got around to preparing that. It's a pretty comprehensive document of frequently asked questions over the thousands of questions that we've answered over the last few weeks. Finally available. We will send out a newsletter that will be going out around 5 o'clock, where you can link to that document and download it. It's also available on our COVID-19 response page on our website. So you should see that shortly. As always, if you have any specific questions, reach out to your HR team. But hopefully you guys can take a look at that. It's a very comprehensive guide with a lot of valuable information. Thanks again, everybody, for coming, and we really appreciate your time.
Yeah, thank you all, and thank you, Regis.
No, thank you, Sumpano and Joe. And just a reminder that we'll have another webinar next Thursday at 2 in reference to the forgiveness of the PPP loan. So again, thank you all. Stay safe, and if any questions, please feel free to reach out to us.